Hi, everyone. I'm Judy the YouTube Lawyer. Thanks for joining in today's live stream where we're going to continue reading the last bits of the filings in the divorce case involving Wendi Adelson versus Dan Markel. So I was hoping that Dawn could join in today, but I was stuck in some traffic. I told her I'd be late. So instead of continuing to wait, I figured I'd just go ahead and start reading. And then when Dawn shows up, then hopefully she can also help me continue reading. Thank you guys for being there. So this is the filing from Dan Markel and his attorney. This was in May of 2014. And as many of you know, Dan Markel was a law professor at FSU, and he was shot in the head on July 18th, 2014. So just about 2.5 months after this motion to compel discovery was filed. Oh, and I see Dawn is here now. Thank you, Dawn. Thanks for being there. Can you hear me?
Yes.
Oh, good. Okay, are you ready to read this?
Oh, I'm on. You put me on.
Yeah, you're on now.
Hi.
Hey, everybody.
Hi. What? All right. Sorry, I'm late. Okay. So which one are we going to start with today?
Okay, so we're going to start with the one that's called Dan Motion to Compel.
Okay.
Okay, do you want me to start?
Sure.
Okay, here we go. Okay, so as you can see, this was electronically filed on May 2nd, 2014. In re the marriage of Wendi Adelson, former wife, and Daniel Markel, former husband. Former husband's motion to compel discovery. The former husband, Daniel Markel, through the undersigned attorney, and pursuant to Rule 1.380, Florida Rules of Civil Procedure, moves this court for an order compelling former wife, Wendi Adelson, to respond to the former husband's second request to produce, and in support of this motion, alleges the following. Number one, the parties have each filed motions to enforce the financial provisions of the MSA, which stands for Marital Settlement Agreement, for which hearing is scheduled on May 15th, 2014. On April 24th, 2014, the undersigned served former husband's second request to produce, as well as a motion to reduce time for former wife to respond to former husband's second request to produce. Number three, the attorney for the former wife filed an objection to the former husband's second request to produce on April 29th, 2014, wherein she objects to production of any of the documents requested in the former husband's second request to produce. See attached Exhibit A.
Number 4, in an effort to avoid unnecessary litigation, the undersigned attorney wrote the attorney for the former wife on April 30th, 2014, and offered to reduce the scope of documents requested to those generated after July 31st, 2013, the date of entry of the final judgment of dissolution. See true copy of letter dated April 30th, 2014 from Scott A. Snavely to Kristen Adamson as attached Exhibit B. Number 5, the attorney for the former wife has communicated her rejection of the offer to reduce the scope of documents requested in former husband's second request to produce, and confirmed her position that no documents responsive to the former husband's second request to produce will be produced without a court order. The information requested in the former husband's second request to produce is within the broad scope of discoverable materials as set forth in Rule 1.280, as the request seeks documents, items, and materials that are relevant to the issues raised by the parties' respective motions to enforce the MSA, and admissible evidence or reasonably calculated to lead the discovery of admissible evidence. Number 7, the undersigned attorney has incurred additional time seeking an order compelling compliance with the former husband's second request to produce, and pursuant to Rule 1.380A4, Florida Rules of Civil Procedure, the former husband is entitled to recover reasonable expenses, including a reasonable attorney's fee necessitated by the former wife's refusal to comply with the requested discovery.
Wherefore, the former husband, Daniel Markel, requests that this court enter an order compelling the former wife to produce all documents, items, and materials responsive to former husband's second request to produce no later than 5 p.m. on Tuesday, May 6, 2014, in order to allow the undersigned a reasonable opportunity to review the documents prior to the parties' scheduled depositions on Thursday, May 8th, 2014, and to impose appropriate sanctions, including award of the reasonable attorney's fees and costs incurred by the former husband in presenting this motion to the court, and for such additional relief as this court deems appropriate. Scott A. Snavely, Tallahassee, Florida, attorney for Dan Markel. Okay, and the last page is probably the certificate of service. Okay. So that was pretty short. And the next one would be the Memorandum of Authorities. Do you have that?
Okay, so that must be
Dan Memo.
Dan Memo Law. Mm-hmm.
Yeah. Okay, so I'll put that up here. Okay.
Okay, and this was electronically filed on May 5th, 2014. Memorandum of Authorities in support of former husband's counter motion to enforce the marital settlement agreement and motion for sanctions. The former husband, Daniel Markel, files this Memorandum of Authorities in support of his enforcement filings since the divorce was finalized. The basis for Mr. Markel's case can be stated succinctly. Overview. The financial matters. Regarding the former husband's counter motion to enforce the marital settlement agreement, in parentheses MSA, and the final judgment entered by this court, the MSA provides clearly that contractual remedies are available to govern disputes arising from the MSA. With respect to those assets not disclosed in the MSA or in the required mandatory financial disclosure, the MSA further provides that the value of undisclosed assets will be assessed and divided equally between the parties, in parentheses 50% each, with attorney's fees provided as well. The former wife's assertion notwithstanding, the former husband is under no obligation to file a motion under Rule 1.540, in parentheses, to set aside the final judgment based on the non-disclosure or fraudulent inducement, as he has the right to rely upon the remedies contained in and contemplated by the MSA itself. Moreover, with regard to the motion to enforce the MSA filed on behalf of the former wife, Mr. Markel relies upon the unclean hands defense, as well as the fact that he was merely exercising the traditional contract remedies available to him under the parties' MSA. In short, because of Mrs. Adelson's material misrepresentations regarding assets subject to equitable distribution, Mr. Markel was under no legal obligation to perform further under the MSA because the remaining financial aspects of the MSA became voidable at his option.
Nonetheless, Mr. Markel has offered to put the disputed assets into a joint tenancy account until the court rules on the parties' competing motions. Additionally, as elaborated herein, it is black-letter contract law that the breaches by the former wife pretermit any obligations to third-party beneficiaries. This means Mr. Markel has no obligation under the MSA to pay the former wife's attorney, who Mr. Markel will also demonstrate has unclean hands and has acted inequitably subsequent to the resolution of the enforcement actions against the former wife. Nonetheless, Mr. Markel has placed the disputed attorney's fees money, $10,000, into escrow with his attorney as a show of good faith. Censure and sanctions. With respect to censure and sanctions of the former wife, Mr. Markel appeals to the court's inherent authority and the case law supporting that authority regarding the sanction available against unclean hands and inequitable conduct. When a party has acted in a way that warrants discipline and reproach, the case law both precludes the party with unclean hands from obtaining relief from the court and also renders the offending party subject to sanctions. The case law makes clear that the former husband is allowed to make the case for both rebuke and remedies for misconduct that occurred both preceding and following entry of the final judgment of divorce. In light of the authorities, allegations showing both pre- and post-divorce misconduct are not only allowed but necessary to advance this defense of unclean hands and to establish the basis for affirmative sanctions against the former wife and/or her attorney. These matters are developed below, in addition to the authorities relevant to interpreting and enforcing the MSA's parenting provisions. Authorities related to the financial provisions of the MSA. 1. Full disclosure obligations and consequences. A. Without warning, Mr. Markel was thrust into an adversarial divorce by filing of the former wife's petition for divorce on September 10, 2012. Under Florida law, from the point that the petition was filed and each party obtained legal counsel, Mr. Markel was justified in his reliance upon the procedures and rules that ensure proper disclosure of each party's financial condition. As noted by the 4th DCA in Daniel versus Daniel, financial disclosure is essential not only in litigated cases, but also in cases which settle. Daniel versus Daniel, 922 Southern 2nd, 1041, 1045, 2006. Strong rules of financial disclosure make the system more efficient by encouraging out-of-court settlements. Conversely, weak and unenforceable disclosure encourages litigation, as formal discovery becomes the only way to ensure that the existence and value of all assets has been disclosed. While evidence of a person's financial condition may be drawn from a multitude of documents, a financial affidavit is a party's formal sworn position that reduces finances to a manageable chunk of information. The affidavit becomes ground zero for any request for post-judgment relief that comes before the court.
The Daniel Court's statement about the centrality of the financial affidavit are relevant here because the property division in Florida turns on the sworn financial affidavits when there are no other agreements created under conditions of trust. As the Daniel Court said, the financial affidavit is central to the job of a court trying to do justice in a divorce case. The property divisions made in the obligations imposed by a final decree turn on the financial condition of these parties. A court cannot do the right thing without sufficient information about the parties' finances. Moreover, a financial affidavit is filed for the benefit of the court and the opposing party in the dissolution. Decisions on whether and how to settle a case depend on a full, honest financial disclosure. The financial affidavit is the center of the system established by the family law rules to resolve the issues that arise in family cases. In this case, a financial affidavit of Ms. Adelson was manifestly defective. Ms. Adelson never disclosed hundreds of thousands of dollars in assets pursuant to the rules of family and civil procedure, yet gave a warranty in the MSA that she had complied with those same rules. See MSA 12.2. Sorry, I think they're cutting down a tree all of a sudden. In parentheses, full disclosure, each party has made a full disclosure to other of his or her assets and existing financial condition as required by the Florida Rules of Civil Procedure and the Florida Family Law Rules of Procedure. The former wife, in her filings with the court, does not deny that she failed to disclose assets as alleged by the former husband. In particular, and this paragraph is highlighted, in particular, Miss Adelson's former Schwab account ending in 9994 and her TIAA CREF account were not disclosed in mandatory disclosure, and together the assets in those accounts are worth over $200,000. The former wife also failed to disclose the existence or value of any of her assets in personal property, automobiles, and jewelry in her possession when those would easily total over $50,000 in jewelry alone. She also understated her salary by several $1,000s, despite being told that she was understating her salary via email on March 7th, 2013. As the MSA attests, Mr. Markel relied upon and by law was justifiably entitled to rely upon the financial disclosures provided by the former wife. Indeed, the MSA includes warranties and representation ensuring full and honest financial disclosure per the Daniel Court. As for any assets that are not properly disclosed, the MSA includes its own jointly agreed upon remedy that the value of the undisclosed assets should be halved, with attorney fees and other costs of enforcement awarded to the prevailing party. Those are the financial rights under the MSA that Mr. Markel seeks to vindicate, and there is ample law supporting his right to do so. Example, Kearney versus Kearney, 129th Southern 3rd, 381 and 389, number 12, 2013. Courts may scrutinize nuptial agreements to ascertain that the parties acted without compulsion and based on full disclosure. Here, Ms. Adelson obviously failed to disclose all the substantial assets owned by her or in which she had an interest. While the former wife may suggest that Mr. Markel was fully aware of the assets in question, such a suggestion would be totally misplaced. First, as a factual matter, Mr. Markel's awareness of such asset is predicted on how he knew about those assets prior to the filing of divorce on September 10th, 2012. It was on that day that the former wife also took hundreds of thousands of dollars of marital assets without any notice or agreement from Mr. Markel. Thus, at any time after that, Mr. Markel was no longer aware of or in control of the hundreds of thousands of dollars of assets to which the former wife helped herself without notice to or agreement of the former husband. The former wife failed to disclose the disputed assets for months after she filed the mandatory financial disclosures, despite discovery requests and despite her oath-bound statements in the affidavit and certificate of compliance with financial disclosure.
Accordingly, to this day, former husband has no knowledge of whether former wife has, among other things, sold or kept the Holocaust diamond ring from his family, a ring that she stated under oath that she would return to Mr. Markel's uncle if the uncle asked for it. Former wife refused to return the ring to the 96-year-old uncle when he asked for it back, and like the ring, there are countless other items that were taken from the home or safe deposit box without the required full and honest disclosure. For all Mr. Markel knows, Miss Adelson might have squandered or conveyed any number of assets at any time after her abrupt departure from the marital home. This is why the Florida Family Rules of Procedure require full disclosures that are made under oath and subject to perjury penalties. In sum, Mr. Markel's knowledge concerning the existence of marital assets can only be deemed adequate if the awareness of such assets exists, where the parties are not estranged and are making agreements under conditions of mutual trust. But those conditions of mutual trust and confidence were exploded by Ms. Adelson's instigation of an adversarial divorce from the outset. Accordingly, both parties are thus required to rely only upon disclosure to ascertain the financial position of the other party. Here, both Ms. Adelson's discovery responses and disclosures are already proved to be false. Put simply, the financial affidavit includes no account ending in 9994 from Schwab. There is no account from TIAA CREF, and there were only zeros listed for all the jewelry, cars, and personal property in her possession. And when discovery was sought in reference to the assets above, Ms. Adelson first falsely claimed that the documents were produced and then ignored the document requests altogether. Number 2, contract principles govern central financial matters in dispute under the MSA. A. Contrary to former wife's assertions in her motion to dismiss, the former husband's counter motion to enforce the MSA, contract law principles are specifically designated under the MSA as available to govern the disputes of the MSA. See MSA Section 9.2. The terms and provisions of this agreement shall be fully enforceable in a court of law as a matter of contract. Such remedies under contract shall be in addition to any and all remedies of enforcement available to the parties pursuant to any final judgment of dissolution of marriage entered between them. B. This is relevant because the MSA itself includes the remedy for undisclosed assets. The value shall be halved, and the attorney's fees and costs of enforcement awarded to the prevailing party. See MSA Section 12.3. C. The MSA recites that both parties relied upon what was in the mandatory disclosures. In an adversarial divorce, the Florida courts have been unwavering in their insistence on strict conformity to the mandatory financial disclosures. See e.g. the discussion of Daniel Supra. D. Contrary to the groundless assertions in the former wife's motion to dismiss, numerous family law cases in Florida interpret marital settlement agreements under general contract principles, e.g. Syverson versus Jones, 10 Southern 3rd, 1123, 1125, 2009, citing and quoting AC Electrical Supply Company versus Terra Nova Electrical Incorporated, 288 Southern 2nd, 522, 547, 1973, Crespo versus Crespo, I'll skip the citations, and Gulf Cities Gas Corp versus Tangelo Park Services.
E. Accordingly, Mr. Markel is not propounding some arcane theory by arguing that the MSA has terms that are to be interpreted as straightforward contractual issues, and that contractual remedies apply, particularly when the MSA itself specifies that the contractual remedies apply. See, for example, Conway versus Conway, 2013. This court reviews a trial court's interpretation of an MSA, as with any contract, under the de novo standard of review. Delicio versus Delicio, 2002. The basic contract law principles on which Mr. Markel relies are found in the restatement second of contracts, in authority that has been cited over 300 times in Florida cases alone, indicating its wide acceptance and recognition by the Florida courts. F. Importantly, the former wife's filings before this court do not deny her failure to disclose the disputed assets on her financial affidavit and certificate of compliance with financial disclosure, nor does she deny that she failed to return the items that she was required to return, nor does she deny that she made the statements in deposition that would return certain items if asked to. In the face of such an obvious set of misstatements and or fraudulent inducements, the former husband's election to delay remitting the balance of the $65,000 in equities or the $10,000 payment otherwise owed to Ms. Adelson's lawyer is not a breach of the MSA, but use of a standard contract or remedy available under the restatement second of contracts, section 164, sub 1, which states that when a party makes a marital misrepresentation, the other party is not required to pay in full and then sue for damages. Rather, the agreement becomes voidable at the discretion of the victim of the misrepresentation. No, once Mr. Markel concluded there's a footnote. Where'd the footnote go? Okay. Once Mr. Markel concluded that there were marital
material
misrepresentations made, he was under no obligation to remit additional money pursuant to the financial aspects of the MSA. However, because Florida law correctly separates the parents' financial disagreements from the other issues related to the children, Mr. Markel has not sought to overturn the parenting plan or other aspects of the MSA related to parenting. Rather, he has elected to enforce the parenting issues. That's because the courts are clear that parenting matters contingent on the presence of a full and honest disclosure. I read that wrong. That's because the courts are clear that parenting matters should remain separate from equitable distribution questions, which themselves are contingent upon the presence of a full and honest disclosure. As the courts in Cherna observed, children are not pawns in their parents' financial squabblings, and the provision for the children's care and maintenance should be considered without concern for such matters. And that's Cherna v. Cherna, 1983. G, as noted above, where material misrepresentation is made by one party to divorce and the other party is permitted to avoid performance of executory financial provisions of their marital contract until the problem is either cured by the breaching party or otherwise adjudicated in court. And that's precisely what Mr. Markel did. Although Mr. Markel believes that he is entitled to far more than approximately $65,000 in equities withheld from former wife, he consulted counsel, a former family law judge, and other legal experts and made good faith initial payment of almost $55,000 pursuant to restatement of contracts. Second, section 205, comment in parentheses E. This is all consistent with Mr. Markel's duty of good faith and fair dealing, which are implied terms to every contract made under Florida law. See County of, I think that's you.
Oh, okay. See County of Brevard versus Miorelli Engineering, Inc., Champaign Weber, Inc. versus City of Fort Lauderdale, Restatement Second of Contracts, Section 205, 1981. There's a quote, every contract imposes upon each party a duty of good faith and fair dealing in its performance and its enforcement. Pursuant to that duty of good faith and fair dealing, Mr. Markel invited constructive discussions at the outset with Ms. Adelson and her lawyer, but those efforts were spurned. The attorney for the former wife filed her motion to enforce the MSA precipitously. The former wife even admitted that her attorney failed to explain the former husband's reason for withholding payments, despite the rationale of his decision having been explained by his attorney during a discussion between counsel. Furthermore, prior to the hearing on these issues, Mr. Markel offered to put the assets in question in the couple's former joint tenant account pending judicial resolution, and the money for Ms. Adamson in escrow. In contrast to Mr. Markel's good faith and fair dealing, Ms. Adelson breached that duty of good faith and fair dealing time and time again on matters pertaining to finances and parenting. H. It should be emphasized that Ms. Adamson's claim for the $10,000 is entirely mooted. Under standard contract law principles, the breach by A of a contract between A and B pretermits any obligation B has to see that arises under that agreement. See Restatement Second of Contracts, Section 309. Illustration 5. B promises A to pay C $100 in consideration of A's promise to B to perform stated services for him. A substantially breaks his promise to perform these services. Whether or not at the time of B's promise, C had a right against A to be paid $100, he has no right against B. Relief for the former wife's attorney is further unavailable because neither the former wife nor her attorney were awarded fees by the court under Section 61 of the Florida statutes. There would have been zero basis for that in light of the substantial and ready asset base available to the former wife, both prior to and under the MSA. Rather, the $10,000 to the former wife's attorney was an extraction demanded by the former wife as a last-second precondition to honoring a parenting offer she had made and then refused to stand by. Because the payment to the former wife's attorney arose under a plain contractual agreement not based upon a court-ordered award of attorney's fees and the need and ability to pay analysis specified in Chapter 61, Florida statutes, the court may not use its contempt power to compel compliance with that provision of the MSA, as was done in Heitzman versus Heitzman, 1973. Rather, the payment to Ms. Adamson arising under Section 7.1 of the MSA was a straightforward third-party benefit whose obligation is entirely erased by the material misrepresentations made by the former wife, misrepresentations with which her attorney was involved. Indeed, it's that involvement that makes Ms. Adamson's efforts doubly unavailing on account of her unclean hands. See infra.
I, as demonstrated in Mr. Markel's response to former wife's motion to dismiss, the MSA does not limit the former husband's recourse for the former wife's misconduct to setting aside the whole MSA because there's a dispute about finances. That would lead to the absurd result in this case that the parties are, in quote, undivorced. Because a section 1.540 remedy might be perceived to allow the undoing of the entirety of the parties' agreements memorialized in the MSA, and there's a footnote. Mr. Markel has opted for a narrower remedy that would not alter the child-related issues and other disputes resolved by the MSA. As noted above, Florida courts are clear that those matters should be separated from the equitable distribution questions, which are contingent on the presence of full and honest disclosure. J. Finally, the parties' MSA specifically includes an where's my brain? In quotes, why can't I say that word? Invalidating. Where'd she go? In a clause that would make it invalid. In MSA section 12.11. This clause itself indicates that the parties intended that the agreement be preserved in all other respects in the event a particular section of the MSA is determined by the court to be invalid or illegal. Mr. Markel's election of remedy simply reflects an attempt to narrow the issues under dispute, in parentheses, rather than to undo the entire agreement that the court's final judgment concerning that agreement, and rely on the remedies bargained for in the MSA, so as not to disrupt the matters already settled between the parties to the court's satisfaction. Section 2. Inherent power of the court to award sanctions based on inequitable conduct. A. Mr. Markel's countermotion on the financial issues call for censure and sanctions against the former wife and her counsel. Those requests are perfectly consistent with this court's inherent power to do, quote, all things that are reasonably necessary to administer justice within the scope of its jurisdiction, end quote. This power includes, quote, control of the conduct of its officers, end quote. And through that power, the court also exercises, quote, the power to sanction attorneys, end quote. See Weissman versus Brahman, 2014. A trial court possesses the inherent authority to impose attorney's fees against an attorney for bad faith conduct. Moakley versus Smallwood, 2002. Patsy versus Patsy, 1996. Trial court's inherent authority includes power to impose attorney's fees against a lawyer for litigating in bad faith. Hahamovich versus Hahamovich, 2014, awarding fees to husband for wife's bad faith conduct and vexatious litigation. Even if the court chooses to censure only the former wife, the court has the inherent authority to sanction the former wife due to her misconduct. And we're skipping footnotes, evidently. Where's Judy? Oh, I think you're on mute. Are you on mute?
Oops, sorry about that.
Okay.
Okay, here we go. Okay, B, specifically under the inequitable conduct doctrine, the trial court may award attorney's fees as a sanction where one party has exhibited egregious conduct or acted in bad faith. Bitterman versus Bitterman, Sumlar versus Sumlar, TF Systems versus Malt. It's important to note that a trial court possesses inherent authority to impose attorney's fees against a party as a sanction, independent of whether there's a financial need or a contractual basis. Bennett versus Burgess, Holt versus Sheehan, which said, quote, to be sure, a court I guess maybe has inherent authority to control the proceedings in the case before it. And this may include publicly criticizing and even sanctioning an attorney for misbehavior in that case, unquote. The inequitable conduct doctrine, which applies in Florida, permits the award of attorney's fees where one party has exhibited egregious conduct or acted in bad faith. Indeed, Florida courts have long recognized that attorney's fees can be awarded in situations where one party has acted vexatiously or in bad faith. See Florida Patients Compensation Fund versus Roe, Hilton Oil Transport versus Oil Transport, In re Estate of Duval. Importantly, the ability to show bad faith is not limited to the actions before the court, but also the actions to the other party. See Dogera versus Safeway Stores. Quote, bad faith may be found not only in the actions that led to the lawsuit, but also in the conduct of the litigation, unquote. Quoting Hall versus Cole, 1973. C. Although the MSA relinquishes Mr. Markel's claim to attorney's fees as a form of support, there's nothing in the MSA that precludes the court from awarding Mr. Markel an amount of money tied to the amount of attorney's fees he has had to expend in this divorce. See Carey E. versus Carey, 2013 case, acknowledging spouse's right to seek and acquire attorney fees because the other spouse had not disclosed financial status in a full and accurate manner. CF, Rabath versus Fareed, 2009 case, affirming that trial court may fashion remedy in light of the lack of completeness of one spouse's financial disclosures. D. To be clear, not counting his own time, Mr. Markel incurred over $40,000 of legal fees with his prior attorney, Mr. Duggar, to address Ms. Adelson's breach of the communication agreement, her failure to perform her disclosure accurately, her spurious petition to relocate, and her bad faith negotiation behavior described in the counter motion. E. Mr. Markel has also had to incur thousands of dollars in post-divorce litigation to address the former wife's frivolous efforts to seek a protective order from being deposed, even though that is a straightforward right of Mr. Markel or any similarly situated litigant. Okay, in footnote 5, he wrote, Professor Markel is a member of the DC Bar, and his hourly billing rate 10 years ago was at or above $400 per hour. In the absence of his own work contributed to this case, the legal fees incurred would have been far higher. and her equally frivolous motions to dismiss or to strike Mr. Markel's counter motions as a sham. Okay.
F, this court must keep in mind that the former wife is not only an attorney herself, but a clinical law professor at FSU who is supposed to exemplify the conduct students should emulate. Instead, there's a record of frivolous motions, demonstrably false statements in court proceedings, failure to comply with discovery requests, falsely answering discovery requests, flouting of court orders regarding parental communication, and concealment of material value of assets in mandatory financial disclosures. That doesn't include the numerous agreements related to the parenting and time sharing, which the former wife disregarded at her whim during the pendency of the divorce. This is all consistent with the former wife's and her counsel's outlandish pleadings practices, where authorities are simply made up or materially distorted. By contrast, the former husband's filings have followed the Florida rules of civil procedure and are detailed, specific, and plausible, particularly when alleging misconduct. And in the course of proving to the court that this misconduct has occurred, the former husband must be given reasonable latitude to pursue discovery that would further establish the pattern of misconduct outlined herein. G, as lawyers, the course of conduct described in part above and as alleged in the former husband's countermotion is clearly covered and prohibited by Rule 4-8.4 of the Florida Rules of Professional Conduct for both the former wife and her counsel. Rule 4-8.4c states that a lawyer should not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Relying on Black's Law Dictionary, the Florida Supreme Court defined misrepresentation to include non-disclosure. See generally the Florida Bar versus Cueto, 2002, defining misconduct at issue here by quoting Black's Law Dictionary 1016, 7th edition, 1999, quoting Restatement, 2nd of Contracts, paragraph 159, 1981. The Florida Supreme Court further noted for the term, quote, dishonest act, end quote, Black's refers to, quote, fraudulent act, end quote, which is defined as, quote, conduct involving dishonesty, a lack of integrity, or moral turpitude, end quote. Quoting Black's Supra at 672, further, quote, moral turpitude, end quote, is defined as conduct that is contrary to justice, honesty, or morality. And in the area of legal ethics, offenses involving moral turpitude traditionally make a person unfit to practice law. And this is quoting Black's Supra at 1026. H, the former wife, with and through her counsel, took a simple divorce and made it complicated, nefarious, and expensive. Unless this misconduct is sanctioned, the former wife will continue to enjoy impunity, and her attorney, and indeed the bar at large, will be emboldened to advise future clients that there are no adverse consequences for ignoring discovery, flouting judicial orders, filing frivolous motions, concealing assets, and falsely testifying under oath. Wow. I, should the court agree with this request to impose sanctions, Mr. Markel is happy to have whatever penalties that are assessed to be put into trust for his children's benefit. I think I missed a footnote again, sorry.
Oh, yeah, if you want to read that footnote 6, that sounds kind of good to read.
Yeah, and I don't know where it belongs, but footnote 6, to clarify, Mr. Markel seeks reimbursement for legal fees incurred both prior to and after the divorce. The basis for collecting legal fees incurred prior to the divorce arises under the court's discretion under the inherent authority and inequitable conduct doctrines that empower the court to award sanctions against the former wife and her counsel, and to use as basis for those sanctions the extensive legal costs Mr. Markel incurred based on Miss Adelson and Miss Adamson's vexatious or bad faith misconduct. With respect to legal fees incurred since the divorce, however, the court must, per the MSA and court's final judgment, award Mr. Markel the attorney's fees he has incurred because of Ms. Adelson's financial non-disclosures and because of the many ways in which she breached the parenting provisions of the MSA.
Number 3, unclean hands. A. Under the doctrine of unclean hands, quote, no one shall be permitted to profit from his own fraud or wrongdoing, and that one who seeks the aid of equity must do so with clean hands, unquote. Yost versus Reeve Enterprises, Epstein versus Epstein, quote, he who has acted in bad faith, resorted to trickery and deception, or been guilty of fraud, injustice, or unfairness will appeal in vain to a court of conscience, unquote. The unclean hands doctrine is regularly applied to thwart the efforts of former spouses with bad behavior seeking to find relief in the court. C.E.G. Fetzer versus Evans, finding that wife who left husband and took child with no disclosed address or agreement and had ignored prior judicial orders had unclean hands. Indeed, courts have had the inherent authority to dismiss an action as a sanction when it learns that a party has perpetrated a fraud on the court. Morgan versus Campbell, 2002. B. Here, the documents filed in connection with the former husband's counter-motion on financial matters show clearly that former wife failed to disclose $250,000 or more of assets in the mandatory financial disclosures and failed to correct the flawed financial disclosures and financial affidavit. This is especially egregious given that the former husband sought discovery concerning the non-disclosed accounts. But in response, the former wife, through counsel, falsely stated that they produced documents in response when no such documents were produced or provided. In fact, the former wife moved the assets from a disputed Schwab account to another account on May 20th, 2013, only 3 days after service of the discovery request on May 17th, 2013, a request that directly implicated the non-disclosed Schwab account. The former husband sought a second time to obtain such documents as well as an inventory of all that was taken from the marital home, but the former wife and her counsel never produced any such documents, even though former wife attested in the MSA that she had made a full financial disclosure in her mandatory disclosure. C. Recently produced discovery shows that there was an account at Schwab ending in 9994 with holdings that would now be worth well over $60,000. The former wife never disclosed that account in the MSA or in her required financial disclosures, nor did she list her TIAA CREF retirement account, presently estimated to be worth well over $150,000, in her financial affidavit. Nor did she provide an inventory of items removed from the marital home as requested in discovery. And she also listed $0 as the value for the car, jewelry, and personal property that she took on her disclosures, which would appear false and misleading on its face. D. The former wife's financial affidavit states clearly that it was prepared by her attorney, Ms. Adamson. At the time it was filed, the affidavit failed to list any value for numerous items which counsel for the former wife knew about because they had been the object of discussions between counsel. For example, Mr. Markel long wanted the minivan. Ms. Adamson knew about that car through letters, and still its value was listed as $0 on the affidavit that states it was prepared by the attorney for the former wife. At that time, and surely subsequently, Attorney Adamson became an instrument of the former wife's misconduct by failing either to correct the fundamental errors in financial disclosure or to withdraw from representation when she became aware that the financial disclosures approved by the former wife were erroneous by omitting disclosure of thousands of dollars in assets that were the subject of discovery requests served by the former husband.
E. Ms. Adamson's continued representation in which she is seeking to gain the third-party benefit from a contract that her client breached, in parentheses, perhaps through her own misfeasance or malfeasance, and parentheses, also presents a clear conflict of interest. Mr. Markel has sought to resettle the issues with the former wife, but her attorney's pecuniary interest is now clearly at odds with that of her client. As mentioned above and documented in an email attached to prior pleadings, the former wife reported that Ms. Adamson failed to communicate to her nature of the allegations, former husband's allegations of misconduct. So either the former wife was informed of the nature of the former husband's allegation of misconduct and she lied to Mr. Markel in her email, or the former wife was not informed, indicating a conflict of interest between former wife and her counsel. F. The former wife also breached numerous and other agreements and acted furtively with regard to parenting and financial issues from the time of filing the divorce. 1. She flouted judicial orders regarding parental communication during the summer of 2013. 2. With respect to various issues at the relocation hearing or in deposition, the former wife gave demonstrably false testimony, claiming, for example, that Mr. Markel refused to offer fixed parenting schedules when in fact there are documents and emails from both him and his lawyer offering such fixed parenting schedules. The former wife on December 31st, 2012, made agreements to long-term schedules that she subsequently denied having made, and then refused to permit long-term scheduling to occur. All of this was bad enough, but she painted an entirely different picture when under oath before this court. The former wife's attorney was aware of prior offers of fixed parenting schedules, but on June 18, 2013, witnessed or invited the former wife's false testimony on this very issue. 3. The former wife, through her counsel, has repeatedly filed baseless motions. I. The petition to relocate was filed without any legal support, and after Ms. Adelson's prior board-certified lawyer had clearly counseled Ms. Adelson that it was impossible to prevail, in parentheses, that lawyer, Ms. Novi, was then replaced by Ms. Adamson, who nonetheless filed the petition and later stipulated to its denial with prejudice, end parentheses. 2. The former wife began the instant post-divorce litigation by filing her motion to enforce the MSA, but then, without sufficient grounds, sought a protective order to prevent her own deposition. 3. The former wife then filed a motion to dismiss Mr. Markel's counter motion, even though that motion to dismiss is itself a sham motion, since the former wife does not deny the allegation that she failed to disclose hundreds of thousands of dollars of assets required financial disclosure.
4. Time and again, the former wife, with the assistance of counsel, has generated needless legal fees, wasted this court's time, and has been lacking in forthrightness, as exemplified by her attorney's recent in-court assertions on 2/17/2014 that the former wife had been deposed numerous times for 8 hours, when in fact there was only one deposition of the former wife, which occurred in June 2013, prior to the relocation hearing and lasted less than 3 hours. The time is long past for such vexatious misconduct to stop. G. In short, the former wife, Ms. Adelson, and her counsel, Ms. Adamson, have unclean hands. Pursuant to the principles outlined in the authorities above, Mr. Markel is legally permitted to make these allegations, adduce evidence of such misconduct, and thereby preclude the affirmative relief sought by Ms. Adelson and or her counsel. Authorities related to the parental rights enforcement of the MSA. A. The legal issues touching on the parenting matters to be resolved by the court are quite straightforward. Since Mr. Markel is asking this court to enforce the MSA's parenting provisions, he notes that some of the MSA parenting language involve rules that Ms. Adelson has broken clearly, while others involve adjudicating whether Ms. Adelson has also violated the standards of shared parental responsibility as articulated in the MSA, which must also be applied. B. Accordingly, the relevant law is as follows. When there is an ambiguity in a contract regarding the nature of the standard, that standard should be resolved by the trier of fact, North Star Beauty Salon versus Arts, Board of Trustees of Internal Improvement Trust Fund versus Lost Tree Village Corp. C. In this context of parenting issues, ambiguities about contractual matters should be resolved in accord with the best interest of the children. Delicio versus Delicio. Ballantyne versus Ballantyne. Benjamin versus Benjamin. D. To assist the court in making those determinations, Mr. Markel has retained an expert in family therapy and child development to opine on what has worked well empirically and clinically for children. Mr. Markel will also adduce the recommendations of the child development expert who is head of the children's preschool. That person, Dr. Phelps, had previously been deposed for the relocation hearing. Regarding the education of the children, Dr. Phelps has unhesitatingly stated to both Mr. Markel and Ms. Adelson in a recent parental conference that the children would substantially benefit from continued immersion in the preschool they've spent virtually their entire childhood, and that in the elder son's case, Benjamin, he would indisputably benefit from an extra year of kindergarten due to his late birthday and the concomitant status of his social and emotional development. She also made clear that it was harmful for Benjamin to be pulled out of school as frequently as Ms. Adelson was doing because it was causing Benjamin to effectively lose an extra day in his transitions back to group play. Despite various attempts to speak to and consult with Ms. Adelson about the children's continuing education, Ms. Adelson has refused to communicate with Mr. Markel her preferences, let alone her reasons, requiring him to ask for the allocation of decision-making authority over matters related to the children, contingent on his consulting family therapists and Ms. Adelson herself.
E. Mr. Markel incorporates by reference the discussions above related to unclean hands and the inequitable conduct so that he may show the court that the former wife's misconduct regarding parenting issues precedes the entry of the divorce as well as occurring after, and therefore such misconduct is relevant to the determination that attorney fees should be levied against the former wife as a sanction. Dated this 5th day of May 2014, and this is signed by Scott Snavely, Dan's attorney.
Okay, great. So then we have the certificate of service. Yeah, just in the interest of time, I'll just scroll through the last couple of documents because it's really nothing substantive. So the second to the last document that I have from their family court case is Wendi Adelson's motion to continue. And it's just a short little document where Wendi Adelson, through her attorney, is asking to postpone because her attorney filed a motion to withdraw as counsel due to a conflict of interest. And she's saying she needs additional time to get a new attorney. So the May 15th hearing should be continued to allow her to get new counsel. Okay, so that was filed on May 7th, 2014. And then the last document that I have is the judge's order, basically granting that and saying they could reschedule it for later.
So Dan was right.
About what?
About that conflict of interest. So the Adamson withdrew her counsel, evidently.
Yeah. I mean, on the other hand, I mean, being a family law attorney, I feel that you can't blame it all on the attorney, because even if the attorney might have signed something, I mean, how can any attorney really remember all the details of every single person's case and what possessions they have? Because typically an attorney who has a full-time practice would probably have at least 25 or even over 50 clients,
Right.
at any given moment. So to say that, hey, the attorney signed off on this thing and she should have known that Wendi had a car because she had a call with my attorney about the car before or something. I don't know. I mean, yeah, granted, the attorney should have been more thorough before signing off on something. I mean, this is just my opinion off the top of my head, having just seen this stuff for the first time. But anyway, as you guys can see, Judge Barbara Hobbs was still the judge on the case, and she said the motion for continuance of the hearing is granted on May 13th, 2014. So of course, nothing was ever rescheduled because Dan was shot on July 18th. So kind of sad to see all these court filings and to hear Dan Markel's side of the story.
It really is, and kind of like walking through the past of what they were going through and what he was going through that led up to this. And it's kind of eerie in a way for me. Yeah.
Mm-hmm. Yeah, just thinking that, okay, what's going on behind the scenes, you
Right.
can kind of like hear in your head like drums pounding, because there's like a conspiracy going on to kill him off, while he's just like, typing up all these things about the ways that he believes Wendi wronged him and mistreated him and was violating this and that and didn't do stuff right. And meanwhile, he doesn't know that, he's going to be killed off because of all this mess.
Yeah, it's frightening. It's really frightening. And it also showed in the document, I forgot which part it was, that Wendi was comfortable with perjuring herself or stating false statements.
Yes, making false statements and just, telling him one thing or just ignoring him and not responding to him and just changing her mind at the last second over things that she had offered or said. So, yes, it's very frustrating to hear these things, assuming that they are true, of course. So there's some questions here. Yeah, unfortunately, I do have to get going to a work meeting soon, so I don't think we'll be able to address everybody's comments and questions, but I really appreciate people still caring about the Dan Markel case and being here today on a weekday. Okay, was there an order related to Dan's motion? So no, this is all the stuff I have from the family court case that we've read towards the end. So there was no order done because the hearing got postponed and then he was killed. So, okay. Hi, Debbie. Premarital assets are protected, right? Was it just non-disclosure or had to do with settlement? Yeah. So typically, not practicing in Florida, typically the premarital assets are not going to be split in cases of divorce. Of course, there are always exceptions, but normally you still have to disclose them. I'm going by what we do in North Carolina, of course, but typically you still have to fill out this gigantic form. It's called an equitable distribution inventory affidavit, where you list all the assets and which ones you claim are separate for some reason or the other, and which ones do you claim are marital. So, so it was both. I think he was saying that she failed to disclose certain things like that Schwab account and her TIAA craft, and she also didn't disclose the value of all these other personal properties like jewelry that she had taken, and that she had basically fraudulently induced him into the settlement. So, was the money accrued during marriage or some inheritance or family money investment? Yeah, I never heard of either one of them getting any sort of inheritance while they were married. So I don't think it was inheritance. But remember that by this time, yeah, so Dan was 41 when he was killed, and Wendi was maybe around 35 at the time, and both of them had worked. Dan had previously worked for like a bigger law firm in DC for a number of years before he switched over to becoming a professor. And as we heard from his mother, he was really into stocks and investments. So even when he was a teenager, he asked for people to give him stocks for his bar mitzvah gift. So he had been investing for a very long time. So I'm not really totally surprised, given that, we know Wendi was also from a wealthy family. So, they could have gotten money from their family also. So I think that's why they had relatively a lot of assets compared to many people getting divorced. Because sometimes you do see people who get divorced and all they have is a pile of debt and no assets.
Right.
Yeah.
Right.
So, okay. Well, Dawn, any other closing comments you would like to add?
Just hey to everyone in the comments. Thank you, Screaming Toad, for the suggestion about my disco ball. Yeah, it's just really serious stuff, and it's very enlightening to understand more about how things in family court can get so heated.
Oh, definitely.
I had no idea about that, and not that Dan, I just see it as Dan is dotting his I's and crossing his T's. That's what a law professor would do. I think Wendi found that annoying and was just sort of throwing up all kinds of dust, in to distract and frustrate him. And it kind of makes sense in terms of what's happened and the way she's conducted herself at the trials. And it's extremely disturbing. And I can see why he would be very frustrated and vexed by this. That was her intention. Yeah.
Yeah, totally. Oh, by the way, why don't we sell your YouTube channel? Because, I keep forgetting to tell people to subscribe to your channel too. So what's the name of your channels again?
Well, my Dawn Dacquisto channels actually refer out to my Beauty Touchdown and Hey, We Like Your Pod. So my podcast is Hey, We Like Your Pod. And my YouTube channel, and we have a YouTube channel for it, but it's a podcast. But we have come to recording it live on YouTube, which is kind of fun. So you get to hear us recording a live stream podcast, which a lot of people are doing these days, in Beauty Touchdowns. I should put the at next time I read for you. I'll put it in there so it makes it easy.
So what's the name of the other channel then? Beauty Touchdown?
Beauty Touchdown, yeah. And that's just myself and my adopted grandkid. I do skincare, she does makeup, and we talk about football every week.
Okay.
Yeah, and it's fun. It's just kind of goofy and fun, and it's for anyone who likes football or likes makeup or skincare or all of the above. So
great. Yeah. Okay, so hopefully we can get you a few more subscribers.
Oh, thank you.
Yeah, so you have two channels. One is your name, and then the Beauty Touchdown.
And then the other channel for the podcast is Hey, We Like Your Pod, which is a little bit more serious.
Okay.
And Hey, We Like Your Pod is basically myself and Matt. We talk about content. In fact, I've actually talked about your channel on this podcast.
Oh, thank you.
Oh, thank you, Screaming Toad. And we talk about content throughout the week, a lot of football related, but I tend to bring up other things, true crime or trials or legal stuff. So including NFL legal things. There's a lot going on in the NFL that ends up being in the courts. So that's kind of interesting.
Cool. Yeah. Okay, well, I hope you get some more support and subscribers then with people who are, just interested in other subjects, including football and beauty and stuff. So yeah. Okay, well, unfortunately, I do have to get going. It's a work day. So thank you so much, Dawn, and hopefully you'll be back to read some more stuff, because we still have Luis Rivera's entire deposition, which could take hours and hours to read.
Yeah.
So
that'll
hopefully
be interesting.
You can help me do that. There's still more.
For sure. Yeah, we'll just break it up.
Yeah. Okay. Well, thank you all. Okay. Have a good day then. Okay. Bye. We'll be in touch. Take care.
Take care.
Bye.